Hello, government students. This is a video lecture for Learning Module 6, and it will cover the executive branch of our national government. These are the learning objectives that I hope you'll be able to accomplish after you've completed all of Learning Module 6. To start out, we're going to look at how the Constitutional Convention considered the role of the president and the nature of his office. This was one of the controversies of the Constitutional Convention, and specifically, those controversies included the number of office holders for the executive branch. Believe it or not, there was a debate over whether there would be one office holder, so one president, or would there be a group of presidents, like a council? And so the concern essentially was that if you place all executive power in the hands of one person, that person would be in a position to abuse it. And so it would be better to spread out that power into a group of people holding executive power. We'll read, it's one of your assignments, Federalist Paper number 70, that goes into greater depth about the debate over how many people would hold the office of the president in the executive branch. There was also a debate over how long the president's term would be. Alexander Hamilton, for instance, was an advocate of a lifetime appointment as a president, but others had varying numbers of years that they thought the president should hold the office. The manner by which the president would be elected was also a controversy. This is connected to the debate over how representatives in Congress would be chosen, the Virginia plan and the New Jersey plan. It was a similar sort of debate. And the powers of the president were also disputed, again, because the members of the Constitutional Convention were not interested in giving too much power to the national government at all. And then especially if we were going to have one person holding this branch of government, it would seem like a dangerous concentration of power. One of the assignments, as I said before, is going to be to read Federalist Paper number 70, and I'll let you work on that. And if you have questions about it, of course, you can email me. Some of the anti-Federalist arguments related to the president were similar to the complaints they had about other branches of government. It's difficult to pinpoint any particular anti-Federalist essay that would be a good counterbalance to Federalist Paper 70. So I haven't assigned one, but I can just tell you generally, they were concerned that the president or the holder of the executive branch would just become another elected monarch, similar to King George. They were worried that conspiracies might develop among the national government to ensure his reelection. And so they were challenging some of the choices made about how the president would be elected. They were particularly worried that the president would abuse his power of veto and his power to pardon. We'll look at both of those powers as we get deeper into this lesson. So their concerns then just sort of match their general concerns about the concentration of power in a centralized government. How these debates were ultimately resolved are shown in Article 2 of the U.S. Constitution. And so I've got quotes from the Constitution inside this PowerPoint in various places so that you can see the actual language. But I encourage you to actually go and read all of Article 2. That's one of the module requirements, so you can see how everything is laid out. As far as the number of office holders goes, the term of office, so how long the president would serve, and then how the president would be elected, all of that comes in the very first section of Article 2. And so I've quoted, it's rather long, so I've only quoted the beginning of it. The executive power, referring to the president, shall be vested in a president, so singular, in a president. So number of office holders, they chose one person. And you'll read Federalist 70 that supplies the justification for that choice. So the executive power shall be vested in a president of the United States of America. He shall hold his office during a term of 4 years. So there you see the compromise on the length of the president's term. It would not be a lifetime appointment. There would be a term of 4 years. And then together with the vice president, chosen for the same term, the same 4-year period, will be elected as follows. And then it goes on to describe the Electoral College, which is something that we'll look at in a little bit. The limit on the number of terms the president can serve, as we know now, is 2. But that was not part of the original Constitution. The 2-year term limit was something that presidents simply chose to adhere to. That it was just a policy choice that George Washington made, and subsequent presidents followed his lead on that. So he sort of established a precedent. He chose not to run for reelection after serving 2 terms. Other presidents followed his lead. They followed his example and only served for 2 terms and did not seek reelection after that. During World War II, when Franklin Roosevelt was in office, he did run for a 3rd and again for a 4th term. And that drew some concern from Congress and the people about the potential for abuse of power that might be inherent in a president continuing to run for reelection. And so they proposed and ratified the 22nd Amendment to the Constitution, which reads, in part, "No person shall be elected to the office of the president more than twice." So that set in stone the official limitation on the number of terms a president may serve, just 2 terms. The powers of the president are provided in sections 2 and 3 of Article 2, which is rather long, but I've got a fairly good list in the next slide for you. There are enumerated powers similar to how Congress had enumerated or listed powers in the Constitution. But in addition to that, a lot of presidential powers and responsibilities have simply been assumed by presidents over the course of history. So a lot of the things that you may see the president doing now were not things that presidents ever did or even would have thought to do 200 years ago, when the founders, the initial leaders of the American nation would never have done all the things that the president is doing now. It would seem ridiculous to them and impossible to accomplish all the things that the president does these days. So as we go through this lesson, I'm going to do my best to point out what powers were actually part of the office of the president originally and what parts have been assumed by presidents over the course of history. And you can sort of analogize it to George Washington's choice about term limits. Nothing required him to step down after 2 terms. He made that choice on his own, and subsequent presidents followed his lead. They followed his example to limit themselves in that way. But then other presidents have taken greater powers. So instead of limiting their power, they've taken on additional powers or perhaps additional responsibilities that they believed were appropriate. And once one president does that and no one objects, then subsequent presidents will follow the lead and continue that tradition, carrying it forward. And as a consequence of that, the role of the president in American affairs has ballooned. It's just grown exponentially to the point where it's really impossible for the president to accomplish all of it. And that is one of the reasons that the office of the executive branch of government, is not just one person. It couldn't possibly be done by just one person. The president must have a staff, must have these executive departments to help him or her accomplish all of these powers and responsibilities that have just kind of fallen into the role of the president over history. So here we'll look at a list of the president's enumerated powers, and these are in sections 2 and 3 of Article 2, except where otherwise noted. One you're probably super familiar with is that the president is the commander-in-chief of the Army and the Navy, and when necessary, even state militias, although that doesn't really happen anymore. However, Congress can declare war. And so the extent to which the president can act as commander-in-chief is dependent upon Congress's cooperation in that endeavor. Congress also holds the power of the purse, meaning they control the funding of the military. So if the president sends troops to fight, then they will be able to fight as long as they have the money to pay for soldiers and equipment and war material. Congress can limit this power by, number one, by refusing to actually declare war and fund the actions of the military. They can hold the president back. So it's not an unlimited power. The president is commander-in-chief, but he's limited by Congress's cooperation. However, there are a few things the president can do unilaterally. One of them is to require opinions from the heads of departments. Essentially, he can insist that the members of the executive departments advise him, give him their assistance and counsel. And as we'll see, that this power of the president to require opinions from the heads of departments supported an expansion of power in the formation of a cabinet, something I'll talk a little bit more about in a second. The president unilaterally can pardon people. This only applies to federal crimes, though, federal offenses. So without any cooperation from Congress, without any approval from any other branch of government, unilaterally, the president can pardon someone from any sort of federal prosecution. Even after someone's been tried and convicted and is serving time, the person can be pardoned. A person can be pardoned before they're even investigated and prosecuted. This pardoning power is broad. The only limitation is that it only applies to federal offenses. The president can temporarily fill vacancies in Congress. This would be something that's just sort of a stopgap measure until a state can hold another round of elections to fill a vacancy in the Congress. And the president will receive ambassadors from other nations, something else that's done just by the president and not with any need for cooperation among Congress. These remaining powers, though, definitely involve Congress because they require the Senate's approval. The president will negotiate treaties with other countries, but the Senate must approve a treaty. The president makes many, many appointments for ambassadorships, heads of executive departments, judges on the federal court system. This appointment power is fairly broad, but the Senate will follow up after so it's just a nomination. The president is nominating someone. Then the Senate goes to the business of vetting the nominee, questioning the nominee, often in public and before the media. So they will have to approve of the president's nominee, or the appointment is not accomplished. One of the responsibilities of the president that is in the Constitution is to deliver the State of the Union address. This is not, he doesn't have to do it publicly, doesn't have to be televised. Those things are new, but he is responsible for reporting to Congress on a regular basis. It's done annually now on just the State of the Union, the extent to which the American nation is accomplishing its policy goals. The president is allowed to recommend legislation to Congress. These would be sort of like proposals for legislation. The president cannot introduce a bill in Congress but his staff can help write a legislative proposal and then give it to members of Congress to be introduced. The president can, in an emergency, force Congress to come together or adjourn Congress and send them home. But this is only going to happen in extraordinary occasions. There is a sort of a catch-all power at the end of this list of enumerated powers. It says that the president is responsible for seeing that the laws be faithfully executed. And that essentially encapsulates what the executive branch is. It is the branch that executes the law, that carries it out. So the president is not a lawmaker. It's not the president's job to enact laws. He can propose legislation, recommend policies to Congress, but it is up to Congress to write the law. And once written, it is the president's obligation to execute the laws that Congress passes. This is a somewhat tricky area because of the way the role of the president has changed a bit over time. But it's the intent of the founders is that the president is really just there to carry out the will of Congress. It is Congress's responsibility to represent the people and the will of the people as communicated to elected representatives in Congress. So that's sort of the way public policy is accomplished. It's the people express their will, their desires to their representatives in Congress. Congress drafts a bill, proposes it, revises it, researches it, amends it, debates it, and then votes on it. And then when a majority of Congress agrees on a legislative proposal, the president is obligated to sign it into law unless he believes that it would be unconstitutional. And then if he believes it's unconstitutional, the president is obligated to veto it. So that's the typical process. Once a law is enacted, it is the president's obligation, it's his responsibility to carry out that law. The veto power is not actually in Article 2. It's in Article 1 as part of the process of how a bill becomes law. And so this is kind of what I just said a moment ago. The original intent is that the only time the president would veto a law was if he believed the law was unconstitutional. It was never intended to be a political maneuver where a president who just didn't like the law that Congress wrote would just refuse to sign it. It was a much more limited power. That has changed over the course of American history, though, beginning with as far back as Andrew Jackson. It became a political maneuver where the president believed that he spoke for the people and therefore he would veto a law he believed were not in the best interest of the people. So that's a shift, a really remarkable shift in the role of the president that occurred fairly early in American history. All right, so these are the enumerated powers. These are the ones that you can find expressly written in the Constitution. And it is important as you're studying to note the distinction between the powers the president can carry out unilaterally without Congress's involvement and powers that require either Senate approval or some sort of congressional cooperation. So make a note of that as you're studying it. Categorize these powers in that way. And then we have to recognize what I was mentioning earlier, that presidents have assumed greater responsibility and additional powers beyond those that were enumerated in the Constitution. And there are a lot of these. So I have different slides for each of them. And I'm going to start out with the least controversial of those assumed powers, and that's the formation of the cabinet. As I mentioned, there's language in the Constitution that allows the president to insist on opinions from members of the executive departments or the heads of executive departments. And so the fact that the Constitution gives him this power to insist on counsel from executive departments implies that the president can form executive departments. And that's what has happened, beginning with George Washington. He established a cabinet. It only had three departments in it at the time. I think the Secretary of Treasury was Alexander Hamilton, the Secretary of War may have been John Jay, and then the Secretary of State. Maybe Benjamin Franklin, I can't recall, but he went ahead and established three executive departments. So this isn't something that was specifically authorized by the Constitution to form a cabinet, but it happened right away. It was necessary. And the cabinet plays a big role in the executive branch. In addition, the president was delegated the power to form a national budget. I don't recall what year. Oh, excuse me, it's 1921. So it was pretty far into American history where Congress officially delegated the power to create a federal budget to the president. So the president formed a new executive department for creating this annual budget. And it isn't an official budget until Congress approves it. So Congress still has authority and control over the budget. It still holds the power of the purse. But they gave this responsibility of establishing a budget over to the executive branch, and it is accomplished through the Office of Management and Budget. Oh, that's the legislation. Budget and Accountability Act of 1921 was the law that delegated this power to the president. The power that, an assumed power that sort of derived from all of this is the establishment of a staff. Early in American history, the president hired people to help him do his job. And you call the people who are doing this work, assisting the president in his executive functions, you call them the West Wing staff, because their offices are literally in the West Wing of the White House. There was a wonderful TV show called West Wing. I've got a little graphic up there. I recommend it to you if you like to watch a lot of TV. That's a great show about the president, a fictional president. Congress has given its blessing on the establishment of the West Wing staff because they fund it. They pay the salaries of the members of the president's staff. So kind of the logistics of it were that the presidents, beginning early in American history, went to Congress and asked for permission to hire West Wing staff members, and Congress gave their blessing and funded the positions. So they're paid positions in the executive branch that Congress has authorized by funding it. We're going to go for just a minute and talk about more specifically about what the executive departments are and then what executive agencies are. So these are two different animals. Executive departments are directly part of the executive branch, and there are 15 of them. The heads of these departments are called secretaries, and the secretary of an executive branch is a member of the president's cabinet. I can just name a few executive departments offhand: Secretary of State, Secretary of Treasury, Department of Homeland Security, the Department of Education, the Department of the Interior, Department of Transportation. The textbook gives a full list of all 15 departments, and you can look up online to see who the heads of departments are, the secretaries of each department. They are a member of the president's cabinet, and these heads of departments, the president nominates them, but Congress has to give their stamp of approval over it. And you'll see that currently with President Trump's second term, he is doing the work of nominating heads of departments, and Congress is doing the work of vetting and approving or not approving the heads of departments. I believe they've approved everybody so far, but it's been a close call for several appointments. But once all 15 heads of departments are confirmed, then the president will have a fully formed cabinet, and that cabinet provides its advice to the president. It helps him make decisions about how to use executive powers. In addition to the 15 executive departments. The Attorney General is also a member of the cabinet. So you have 15 executive departments represented in the cabinet, plus the Attorney General, to give you 16 members of the president's cabinet. The vice president often comes to cabinet meetings as well, but he's technically not part of the cabinet. Now, executive agencies are slightly different. These are bureaucracies. They are sort of quasi-governmental institutions, and we have a whole lesson devoted to the federal bureaucracy. I just wanted to point them out to you here because they relate to the president, since the president forms several of these agencies. So some of these agencies answer directly to the president, some answer just to Congress, some answer to both the president and the Congress, just depending on the circumstances. But these agencies are there to implement public policy. So they're there assisting Congress and assisting the president in government functions, even though they're not technically part of either branch of government. Some examples of the federal bureaucracy or these agencies would be things like the Securities and Exchange Commission, the federal Communications Commission, the FCC, the FDA, Food and Drug Administration. Those are just some examples. NASA, there's another one. These are all executive agencies, or they're parts of the federal bureaucracy. And again, they're just the technical expertise that are needed to assist Congress and assist the president in carrying out government functions. They're just implementing the public policy under the sort of control and oversight of Congress and the president. So we'll get to our discussion of the federal bureaucracy in greater depth later on. Okay, so we were talking again about powers that the president has assumed above and beyond what is enumerated. And next, we're getting slightly more controversial when we talk about the president's war powers. And we know that the president is the commander-in-chief of the Army and military. So the typical process is that something will happen that will cause Congress to declare war. And once Congress declares war, then the president takes control of the military, and with the advice of the chiefs of staff in each branch of the military, he conducts the war. But what happens in reality is that an emergency happens. Something occurs abroad in another country, or our country, as in the case of World War II, is directly attacked on American soil. The president doesn't have to wait for Congress to declare war before sending troops to respond. So the reality is that troops are sent by the president right away. The president responds immediately when we're attacked and sends troops to fight. And then Congress will gather together and make this an official declaration of war. And from that point forward, fund the operation of the war. Remember, Congress holds the power of the purse. So you have to have Congress's cooperation in the exercise of war powers. So that was typically how the war powers developed. But presidents have assumed a bigger role over the course of history, and have in some cases actually provoked a war, or have sent troops into foreign countries without an official declaration of war and kept them there for quite a long time. Some examples of that would be Korea and Vietnam. Congress never declared war against Korea, but we fought for 3 years in Korea during this would have been during the Cold War time period. When I say Cold War, I'm not talking about an official war. This was just a battle against the spread of communism. So as communism was spreading throughout Asia, our nation responded to try to prevent it from spreading through Korea. And so the president sent troops to Korea to help the South Koreans fight against the spread of communism. And they were there for 3 years, and millions died. It was a bloody, bloody war, although never actually a war, never officially a war. Same was true of Vietnam. And so this sort of extension of power that was demonstrated by the president prompted Congress to pass the War Powers Resolution, to kind of rein in the president in this area of war powers. And what the War Powers Resolution required, was that the president must get approval for sending troops, after they've been there for 60 days. So essentially, the president can respond immediately, send troops into foreign nations, or deploy troops here, on American soil. But within 60 days, Congress must approve it. And if they don't approve it, the president must call the troops back. And so that is a way for Congress to sort of rein in the president's war powers. Another assumed power is the idea of executive privilege. This was first asserted early in American history. I can't recall exactly which president first asserted a privilege, but it was established by presidential tradition. So it's just one of those things that one president does, and there may be some pushback temporarily, but it's a legitimate power, so it is allowed to continue and be used by subsequent presidents. And all it is the right of the president to withhold information from the public, to refuse to hand over, in like present day terminology, refuse to hand over emails or text messages, or refuse to hand over some sort of papers that reflect communications the president has had with other advisors. So it's essentially to give the president some ability to speak frankly, and discuss different, it could be something like in the prosecution of a war, how to handle some sort of diplomatic crisis. The president needs the freedom to speak plainly and without fear that what he says is going to be disclosed to the public. It's sort of similar to getting advice from an attorney or advice from your doctor. You need to be able to speak frankly without fear of reprisal for what you said in that context. So the president can assert this privilege, and if Congress or a court were to issue a subpoena to the president to get information from him or her, the president could say, no, this is privilege. I don't have to give you this information. It will invariably go up to the U.S. Supreme Court, and the U.S. Supreme Court can either insist that the president turn over the information or not. And that usually depends upon the nature of the communication and whether it is really something that should be kept confidential. So oftentimes, I'm just telling you this from my experience as an attorney, what often happens is whatever documents are being withheld under an assertion of privilege, the judges will actually see it. They'll read it. They'll know what the information was. And they have to be able to do that in order to decide whether the information should be privileged or not. And so they can, this is called a review in camera. So it's kind of a legalese there, in camera. So it's just the lawyers, just the judges reviewing the material to see whether or not they agree it should be privileged. And in only very, very limited circumstances will they allow the privilege to apply. And there are many ways to limit the disclosure to just a few people. That's another option. Rather than making something totally public, throw it up on the internet, that public, there are ways to restrict its dissemination to just a select few people. That's another option than absolute privilege. Another form of, or another power that the president has assumed, and has been carried forward just by tradition, is something called signing statements. And this is relatively benign. It's just the president kind of explaining his point of view about a law that he's signing. It's kind of just in a statement of his opinion about the law, how he plans to implement it, perhaps. Then here again, another power that the president has assumed over time is to the ability to enter into executive agreements. This is similar to treaty making. Executive agreements tend to be limited to just trade agreements, and they don't have as big of an impact as an official treaty with another nation. It's just more about trade policy, international trade policy. Some examples of executive agreements are NAFTA, and then it was rewritten by Trump during his first administration, given a different name, the U.S.-Mexico-Canada Act. So not quite so creative of names here, but these are just executive agreements. Congress doesn't have to really sign on to them, but Congress does approve them because Congress would cooperate with them through funding. So if Congress doesn't approve of an executive agreement, they show their disapproval by not funding it. So that's kind of the way that Congress's cooperation becomes essential to executive agreements, even though they don't have to give an official approval because it's not actually a treaty. Okay, now what is perhaps the most controversial, well, maybe not entirely the most, pardoning power might be the most controversial, depending on the person, but one that we're seeing in the news media now with Donald Trump's second term in the White House is the issuance of executive orders. And so I actually have an assignment. One of the learning module assignments for you is to look at some of the executive orders, past and present, and look at how they've been used and the way they are being used today, because it's changed. Every president in history, except for William Henry Harrison, has issued an executive order or proclamation. They are currently numbered. They weren't originally given any sort of number, or so they weren't sort of cataloged until more recently. They would have been called a proclamation. Nowadays, though, that each one is given a number. They're chronicled in the National Archives and in the Federal Register. You can see a list of them. They each have a date and a number. It's kind of more organized now. But they are very common. This is not something novel that only recent presidents have done. Actually, currently, the rate at which executive orders are issued is fairly limited compared to what presidents in the past have done. If you look over the course of history, presidents during the progressive era are the ones that issued the most executive orders. The more recent presidents really haven't issued quite that many. But we'll see what happens with Donald Trump's second term, because it's looking like it's going to be a lot. An executive order has the force and effect of law, but they are not always approved of by Congress. So Congress can interfere with an executive order by not funding what was ordered. So holding the power of the purse gives Congress a lot of leverage. Sometimes Congress will support it. And so the typical process is that Congress would enact a law that gives the president authority to implement some particular public policy. Then the president issues an executive order directing one of his agencies or departments to implement the law. So that was the traditional use, was for the president simply to carry legislation into effect through an executive order, through directing a department to do what the legislation calls for. That's the traditional use of an executive order, and that is the appropriate use of of an executive order. It is the job of Congress to create public policy. It is the job of the president to execute public policy. And so that's why the traditional order is Congress issues a law first, then the president issues an order to implement or carry it out. So it's really just the president cooperating and fulfilling his traditional role in the national government to execute the laws written by Congress. And there you go. Congress passes a law, then the president directs an agency under his or her control to carry it out. That's the traditional use of an executive order. More recently, however, presidents are now using executive orders to set their own agenda, sometimes in defiance of Congress. This in particular may happen when Congress is controlled by the other party. So, say you have a president who is maybe a Democrat, and Congress is heavily Republican. Congress is, carrying out a Republican Party agenda. The Democratic president doesn't like that. And so the president will very quickly issue an executive order to try to circumvent Congress. Or it could be a situation where Congress is deadlocked. They can't come up with a joint consensus on what a policy should be. This was like the case with immigration. Congress is deadlocked in immigration. No new laws were getting passed to handle immigration. So President Obama issued an executive order to implement a policy that he thought was best. And that drew the ire of several members of Congress because they felt like he was abusing his power. But that is exactly what subsequent presidents did as well. When Congress either was deadlocked or was doing something the president didn't agree with, the president defied Congress or is defying Congress and issuing executive orders against Congress's wishes. So that's the more recently what has been happening is the president is using executive orders to circumvent the authority of Congress. And that is the reason why many of Donald Trump's executive orders in his second term are locked up in the courts now, because he's going about the executive function in a different way than is what the Constitution provides. There is a constitutional way to accomplish a policy agenda, a constitutional way the president can go about affecting public policy. Executive orders is not a constitutional way to do that. However, it has been being done a lot these past few weeks. I have a few things about executive orders for you to consider. Something you'll see when you start actually looking at some examples. You'll see that in the executive order, the president will always cite some enumerated power that the order is connected to. And it's often as commander-in-chief of the military, that will be the sort of the power foundation for issuing the order. You'll see that in all of them. And a risk that is taken is that executive orders can be overturned by the courts just the same as a law can be overturned by the courts. So that, we're seeing several of President Trump's recent executive orders are locked up in the courts right now. They're going to evaluate and determine whether the president is abusing his power in issuing the executive order. And they may or may not invalidate the executive order. So it'll have an executive order will have the force and effect of law until and unless they are overturned by the courts. And then, as is often the case in the modern use of executive orders, if the next president doesn't like an executive order issued by the previous president, they'll be revoked. So this has happened. The past 3 presidential administrations, we saw a marked increase in these revocations of previous executive orders. You can look at the data on that on a graph and see the number of executive orders nowadays that are being used to revoke previous executive orders has spiked within the past decade. Some examples of executive orders are the Emancipation Proclamation. Again, this is Abraham Lincoln, his effort during the Civil War. And it wasn't a numbered executive order. It's just called a proclamation, but it is an executive order. And that's a founding document for this course, something you're required to study. And that's why it's part of one of our learning module assignments is to read that. Another one you may have heard of is the Japanese internment order. This was during World War II. It was issued by Franklin Roosevelt. And sadly, it called for the let me think of the right word. it was the forced removal of Japanese Americans from their homes, and they were moved into camps, internment camps, in other parts of the country during the course of World War II. It was a tragic moment in our history for this to have happened because it was not based on any evidence at all. No Japanese Americans were ever determined to have been spies. It was just a suspicion that Japanese Americans living along the Pacific coast would engage in spying on behalf of Japan. That was the reason for the order. But there was no evidence that had ever occurred. And so it was a mistake. But something that it was an irreversible decision, and it caused a lot of damage to civil liberties. Some, however, have been good, such as the desegregation of the military. I believe that was done by Harry Truman, and it was accomplished during World War II. Or maybe subsequent to. No, it was during World War II. Yeah, so it would have been Franklin Roosevelt. The formation of an executive agency can occur through an executive order, such as the Environmental Protection Agency, formed by Richard Nixon. And this is just a graph to show you about the number of executive orders. I wish I had a better graph that showed a longer term perspective of it. So presidents during the progressive time period, the early 1900s, were responsible for issuing the most executive orders ever. More recent presidents haven't been issuing quite so many. But I wanted you to see the trend now is to issue several executive orders early in office. So they aren't necessarily going to continue at this rate throughout a presidential term. But this, at the very kickstart of an administration, we usually look at the first 100 days in office and create this comparison of the number of orders issued during those first 100 days. And you can see that that number has jumped exponentially with Donald Trump's second term. All right, so that sort of concludes our listing of executive powers, enumerated powers, and assumed powers. And now I want you to apply some critical analysis to executive powers and think about what is your opinion on how presidential powers ought to be used. In Federalist Papers 70, you'll see a quote that Alexander Hamilton wrote where he's encouraging the ratification of the Constitution and showing how it is wise to just have one person hold the office of president. And one of his justifications is that we need a vigorous executive, energy in the executive branch. And so I want you to think about, well, what does that mean? What does it mean to have a vigorous executive? What types of things are we expecting him to do so energetically? Do we mean we want him to take direct action, to do things unilaterally without seeking Congress's approval first? Examples of that happening would be executive orders, sending out troops without Congress's approval or declaration of war, pardoning people. Those are unilateral actions. Is that what you think is energy in the executive or a wise use of executive power? We have to think about the consequences of that. We do want the president to be able to act quickly in times of emergency, particularly when we're attacked. In a war, we need quick action, decisive action. But it is so easy for these unilateral actions to be undone because they aren't approved of by the other branches of government. The other branches weren't consulted. And it could be considered an abuse of power when the president takes unilateral action, particularly when the president's defying Congress. That's a problem. Another way presidential powers can be handled is through cooperation with the other branches of government. And this is most likely to last because when you have, the other branches of Congress cooperating with you, supporting your move as president, then your move will last. It won't be challenged by the courts, or it's much less likely to be challenged by a court, much less likely to be challenged by subsequent presidents. They'll be longer lasting because you've taken the time as president to build a consensus, to build political will and support for what you're doing. An example of that is the Affordable Care Act. Sometimes people call it Obamacare, unfortunately. It was a legislative measure, though, that President Obama's administration originally crafted, but he went about it a different way. He didn't issue an executive order that forced it upon the country. He sent a legislative initiative to Congress, and then Congress changed it in a bipartisan way, wrote out the Affordable Care Act, adopting many of President Obama's initial proposals, but then adding their own, changing it, and you get bipartisan support for the Affordable Care Act. It becomes law, and the U.S. Supreme Court has upheld most of it. And it's with us still, 15 years later. This is an example of checks and balances working in our government when the president goes about public policy through this cooperative effort. And then a final way that we see presidents exercising their powers is by kind of circumventing Congress and going straight to the people. And this is kind of fun to look at because it is affected by technology. Here are just some examples of the ways the president it's called going public. The way the president has gone directly to the people to garner their support for a policy measure before even approaching Congress with the legislative agenda. So here, if you look at the bottom left corner of your screen, you'll see a news article where Ulysses Grant is depicted there in a picture next to a woman who I believe is meant to be Lady Justice. So this actually is sort of propaganda that Grant was using, but he's going straight to the people. He's using the media to communicate a message. Move up from that, you see Theodore Roosevelt. He's known for exercising something called the bully pulpit, where he would speak. He'd give public speeches to people. Often, he'd ride along on a train. I think that's where he's standing there in the picture, talking to the people. Most well known, perhaps, is FDR's fireside chats. He used new technology, the radio, to communicate with citizens by talking on the radio directly to citizens, explaining his policies to them, encouraging them to support his policies. Contact your congressman and let him know that you want this, or here's how this law works and how it's going to help you in your daily life. He talked directly to the people, not down to them. He didn't patronize them. He was just kind of plainly stating the implications of the policies that he and Congress were carrying out. So then technology changed again. You had the TV that became the new medium through which the president could speak directly to the people. And then those last two blocks are through social media and the internet, where presidents are now using the newest technology to communicate directly with the people. So those are your three ways that you'll see the president carrying out his or her powers, is through these different mediums and processes. All right, we're going to take just a minute now and talk about the vice president. The Constitution doesn't say very much about the powers of the vice president or the role of the vice president. It does provide that the vice president will preside over the Senate. So it's constitutionally required that the vice president serve as the president of the Senate. But that role is pretty limited. The vice president's really just there to break a tie. Congress can sort of give the vice president a little more authority than that. And so that role has kind of shifted a little bit. But that's what the Constitution says. That's pretty much it. Preside over the Senate, and the vice president is clearly in the line of succession. So if the president passes away, vice president steps up. Originally, the vice president was just the runner-up in a presidential election. So really, it's kind of pitiful. The person who lost the election is obligated to serve with the person who beat him in the election. So the winner gets to work with the loser in the election. And that's how it was for the first few presidential elections. But that changed. And presently, the vice president is actually the running mate of the president. And it's what often happens. You may have noticed this just from the past election, if you're paying attention. You'll have a large group of people running for president. And then over the primary season, that kind of panel of candidates is culled down to just one or two. Ultimately, you have a party nominating someone to be their candidate for the president. And during this sort of announcement time, the president will choose a running mate. And they usually choose someone who was running for president, who had been running, but didn't get enough support. And so the president then chooses that other person to be his or her running mate. It didn't always happen that way. It's just what often happens. So they choose this running mate, and then they run on a ticket. So it's like the Republican ticket would have two people. It would have the president and the vice president, or the president's running mate. And it's a political strategy. They're going to pick someone they think can draw in additional voters. But the responsibilities of the vice president, other than what the Constitution provides, is really just determined by the president. Whatever responsibilities he wants, or she wants to delegate to the vice president, that becomes the vice president's responsibility. Okay, now let's talk about how the president gets his job. I mentioned early on in the lecture that one of the controversies of the Constitutional Convention was over how we're going to elect the president. And so we'll see now how that works, how the president is elected. The Constitution provides certain qualifications, but there's only a few of them. The president must be 35 years old. The president must be a natural born citizen of the U.S., and the president must reside in the U.S. for at least 15 years in order to be qualified to run for office. As far as how the president would be elected, so let's assume that a person is qualified. How do they get to be elected? The proposals included this. Congress could select a president. That was one of the proposals during the convention, is that the people would not be involved in electing a president. Instead, the legislative branch would choose the leader of the executive branch. It's not unheard of in other countries. And so it was sort of the natural suggestion was for when America was forming its national government to give Congress that authority to select the president. But the concern was that would be a violation of separation of powers. If Congress could choose who's in the White House, then Congress essentially controls the White House. So that proposal was shot down. Another proposal was that it would be a direct popular vote. So all the people of the nation would come together and vote directly to elect a president. That was shot down as well. The public at that time period wasn't as well educated and wasn't as informed about the candidates just due to communication technology. There were just so many limitations on access to information. So members of the public would be less likely to even know who the candidates were, what they were doing, whether they would be good as presidents or not. So that idea of having a direct popular vote was shot down. And the compromise then was to establish a group of electors that we now call the Electoral College. So this is a separate group of people. This is not Congress. This is not state legislatures. You can't be holding any public office if you want to be an elector or a member of the Electoral College. But they will be political elites. There'll be people who are very savvy in politics. Maybe they've been engaged in the political business, but are not currently holding office in any government. And they are selected by the people to go and speak on the people's behalf in the election of a president. So it's this sort of intervening body, this intervening group of people that kind of comes in between the people and the president to choose the president. And that's what the Electoral College is. And it's set up in a fairly elaborate part of Article 2 of the Constitution. This is just a tidbit of it here on this slide. Each state shall appoint in such a manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress. So we'll hash that out. The number of electors each state may send to the Electoral College is equal to the number of people in a state's congressional delegation. So you would take a state, we'll say South Carolina, for example. How many senators does South Carolina have? 2. Every state has 2 senators. So you add that 2 to the number of members in the House from the state. South Carolina has 7 members in the House of Representatives. So that's 7 plus 2 equals 9. South Carolina has 9 electors in the Electoral College. So that's how the number of electors each state may send to the Electoral College is determined by the number of their members in their congressional delegation. And you notice here also it says in such a manner as the legislature may direct. So they're referring to state legislatures here. State legislatures control how electors are chosen. The only limit on that power is that members of the Electoral College cannot hold public office. So each state kind of has their own system for choosing electors, and there's a lot of commonality to it. Excuse me. There's a lot of commonality to it, but then there's some variation. And I'm going to point out one in particular, and that's called the winner takes all approach. In 48 of the 50 U.S. states, the electors are determined by who wins the popular vote in just that state. So if, let's say in South Carolina, the popular vote, so this is just South Carolinians voting, the state popular vote, the majority of South Carolina voters cast a vote for Donald Trump in the last presidential election. That meant all 9 of South Carolina's electors would cast a vote for Donald Trump as president. Now, this is can be seen as unfair because the other person, Kamala Harris, also won quite a few votes. I believe a third of the votes in South Carolina were cast in favor of Kamala Harris, but she got none of our electors. That's called the winner takes all approach. It is not proportional to the popular vote at all. It's winner takes all. So that means even though a third of the people in a state may cast a vote for the other guy or girl, the winner, we're just talking simple majority, the winner takes all electors. There are 2 states that do, however, apportion their electors by the popular vote. So in that situation, if 1/3 of the people in a state cast their vote for one candidate, that candidate would receive 1/3 of the electors that go to the Electoral College. And that's a little bit, it's a little bit of a better reflection of the will of the people when you apportion electors based upon the popular vote, the actual popular vote. The election process, Electoral College is just part of the overall election process. So I wanted to take a time in this lesson to kind of go through the election process. And I'll show you where the Electoral College fits in. It has 2 stages, a nomination stage and a general election stage. And so we're going to start with the nomination stage. Qualified individuals, so we looked already at what are the qualifications: age, citizenship, and residency. Anyone qualified by that age, citizenship, and residency qualification Anybody can declare their candidacy. And they just are essentially throwing their name in the hat. They file a form that says they would like to be on the ballot. Typically, when they do so, they'll declare a party that they will seek the nomination from either the Republican Party, the Democratic Party, or perhaps one of the third parties, the Green Party, the Libertarian Party. They can declare that they want to be nominated by a specific political party, but they don't have to. They can claim that they are independent candidates, that they are unaffiliated with a particular political party. But again, as long as they're qualified by the Constitution, anybody can declare their candidacy, and that'll start first. And then they immediately campaign. They try to appeal if they're seeking a party's nomination. They're going to try to appeal to the party's base, and so you'll see speeches, advertisements on television, things coming to you in the mail, things on the radio, things on the TV, heavy campaigning to try to win the election begins right after someone says that declares their candidacy. Then you enter the process of gaining a party's nomination. And so this is where political parties start to get more involved at this stage. So how it kind of works is, so initially, before political parties really took root in America, the candidates would simply campaign in a very subtle way. They wouldn't necessarily ask someone to vote for them. They may not even say much about the fact that they're running, but people would know and talk about it. And so parties weren't really involved. It was more just sort of a group of people who were knowledgeable about politics, understanding who was running for office and choosing who they thought would be the best choice. But over time, as political parties formed, they started taking control over this nomination process. And it kind of happened on a state by state basis. So they're running alongside each other. States would be determining state political parties would be determining who they wanted to nominate. They'd have these sort of caucuses and agreements at the state level of who they wanted their party's nominee to be. And then they sort of told the national party overall who to choose, who to vote for. But things kind of changed in 1824, the election, in 1828, the election of Andrew Jackson. That's where political parties really got involved. It really became the way to get nominated. So now what it is state political parties hold something called a primary election. In some states, it's called a caucus. I think the state of Ohio has a caucus, or Iowa, excuse me. There's the Iowa caucus, but then there's the South Carolina primaries. They may be called something different. They happen in slightly different ways, but it'll happen on the state level, and it will happen by party. So you have a Republican a Republican primary and a Democratic primary. And those primaries are really just about which candidate a political party will nominate. And so it narrows down the field of candidates a lot. You'll have a primary election for the Republican Party in each state. And as each state holds its primary and we see who's winning the primaries in the various states and who's not, the people who tend to be losing step down from their candidacy, give it up, and endorse the winners of the primaries. So they kind of throw their political support behind the person who's actually starting to win a lot of these primaries. And it sort of narrows down the field of potential nominees for the Republican Party, but the same thing's happening for the Democratic Party as well. They do it the same way. State by state, the Democratic Party will hold a primary election, narrowing down the field of Democratic candidates to just one or two people. And then you have in the summer, this will happen the summer before the general election, the national parties will hold a convention. There'll be a national Republican convention and national Democratic convention. And during these conventions in the summer before the popular election, Each party declares their nominee, and then the nominee will declare his or her running mate, their vice president. So now we're in the general election stage. We move to the popular election that occurs nationwide. It always happens in November. It is it's explained in the Constitution exactly what date it will be. It's like the first Tuesday after the first Monday of November, something like that. That is set in the Constitution. Votes then will be counted at first in voting districts. So voters go to the polls on that November Tuesday, cast their votes, and then the poll workers in each district, each voting district will count those votes. And then they send their votes. So you see this picture here, the voting booth. Here are the poll workers counting the votes in their district. Then they send that vote count to the governor, and the governor of each state certifies that the vote is valid, that there was no fraud involved in the election, and that this is the authentic vote count for his or her state. So it's called canvassing and certification, the governor giving his or her stamp of approval on the vote count. Now is when the Electoral College comes into play. Based upon the vote count in the popular election, the electors that the state will send to the Electoral College is determined. Although votes are cast by us, the voters, in the name of a specific candidate, what we're actually doing is choosing the electors that will go to the Electoral College on our behalf. So that's what you're actually voting for. You're not directly voting for the president. You're actually voting for electors who will then go and cast a vote for the president. And in most states, the electors will cast a vote for the person who's been nominated by their political party. In the winner takes all approach, as I was just talking about earlier, the electors for the candidate who wins a majority of the state's popular election will attend the Electoral College, all electors. Even if, let's say the split could be really close. It could be like 49% of the votes went to one candidate, 59 of the votes went to, 51 of the candidates went to the other candidate. I'm saying that wrong. 49% of the votes went to one candidate, 51% went to 51% of the votes went to a different candidate. That 51% is enough to win the popular election. And in a winner takes all state, all electors go and cast a vote for that person, even though nearly half of the state's popular votes were cast for someone else. So it is not proportional at all in most states. The electors then who are chosen in the popular election will gather usually in mid-December in the Electoral College, and they tally up their votes. If they're there for the Republican Party, they will tend to cast their vote for the Republican nominee, same for the Democratic. Here's some language from the Constitution that lays this out. The electors shall meet in their respective states and make a vote by ballot. Originally, it was done they're voting for two people, sort of quirky little part of the Constitution is they're voting for two people at once. And that got a little bit complicated. And so we changed it with the 12th Amendment that made it into a two ballot measure. So now it's a little bit easier to, we don't as often run into a place where no one gets the majority of the electoral votes. And when that happens, the election then is thrown to Congress and it becomes a big mess. It was a big mess in 1804. So that's why they modified the process a bit. But then the electoral vote count is sent to Congress directly to the president of the Senate, who we know is actually the vice president of the United States. And the vice president of the United States meets with Congress on January 6th. That date is actually in the Constitution now. January 6th is the date that the Congress gets together to officially count the votes of the Electoral College. And that there is a picture from the 2024 election. I can't recall the name of the woman who's speaking there, but she is counting the votes, electoral college votes from her state. And then you see the Vice President Kamala Harris there receiving the count. And oddly enough, the loser in the presidential election had to certify the winner, her opponent, Donald Trump. That's the job of the Vice President, to hopefully, with grace and dignity, accept that they lost and officially certify the winner of the winning of their opponent. It takes 270 electoral votes to win the presidential election. That amount is determined by taking the number of delegates in the Electoral College, 538, dividing it in half and adding 1. You get 270. That would be the majority. A simple majority of the Electoral College is 270, and that declares the winner of the presidential election. All right, so I've tried to sort of express to you some of the debates about the virtues, advantages or disadvantages of the Electoral College. I'm saying it that way because there is a call for changing this process. Several states, 15 or 16, have entered into something called the National Popular Vote Interstate Compact. And these are states who believe that the Electoral College system is not fair because it isn't proportional. They're particularly attacking the winner takes all approach. That's really the crux of the issue. And so I'm going to play this video here of a person who's going to describe the Electoral College and then describe the advantages and disadvantages of it.
Remember back in 2016 when Trump became president by winning the Electoral College but lost the popular vote? Anti-Trumpers weren't so happy about that. And it kind of sparked a renewed interest in the age-old debate about the Electoral College. Wait, did I just say age-old debate? Yeah, I did. Because this is something our founding fathers were actually arguing about when they wrote the Constitution. Crazy, right? New presidential election coming up, there's a lot of chatter about the value of the Electoral College. So today, we're going to get into it. Should we get rid of the Electoral College? Okay, so for a quick primer on the Electoral College, let me put on my professor glasses and cardigan. Thank you so much. Yeah, there we go. Now, youth, the Electoral College is not an actual college where you go to study. It's a process. It's how we vote for our president here in America. When you go and cast your vote, you're not really voting for the president. You're actually voting for electors who then go and vote for the president. Now, we've created a fancy animation to help explain the numbers to you. Animation, please. There are a total of 538 electors. Each state and DC gets at least 3. And then the rest are based on the state's population size determined every 10 years by the US Census. Here's what the 2020 electoral map looks like. So, California gets the most with 55, then Texas at 38, then Florida and New York at 29, and then you've got some small states like Montana, Wyoming, and the Dakotas that get 3 each. And you need 270 electoral votes to win the presidency. Look at that, everybody. We all just learned something together. Please stay in school, guys. Please and thank you. Then the general election happens. In most states, it's winner takes all. This means that the party that wins the state's popular vote sends all of their electors to cast votes to elect the president. So if a Democratic candidate won the popular vote in California, then all 55 electoral votes go towards that candidate. But there are 2 states, Nebraska and Maine, who divide up their electoral votes based on who won the popular vote in each congressional district. So at this point, you might be thinking, who are these electors? Can I be one? Well, they're usually chosen by each presidential candidate's political party and are often higher-ups, like big-time Democrats or Republicans. Bill Clinton was an elector for the Democratic Party in New York for the 2016 election. They just can't currently be in office. So since I'm not rubbing shoulders with any of these people, I probably won't be an elector anytime soon. Darn. Okay, so that's the Electoral College in a nutshell. But why do we have it? Well, way back when the United States was becoming the United States, the founding fathers met in Philadelphia at the Constitutional Convention in 1787 to figure out the major laws for how this whole government was going to run. And out of that came the Constitution. As with most things in politics, there was a lot of fighting. And one of the most hotly contested topics was how we elect our president. I mean, when our founding fathers were hashing this all out, they didn't really have any good examples for this type of thing. They were basically just trying to avoid being an oppressive, corrupt monarchy. So, on the one hand, you had the Federalists, who thought Congress should elect the president. And then on the other, you had those who thought the president should be elected by popular vote. But both were a little problematic. First, if Congress elected the president, then Congress would have way too much power and things could get corrupt real fast. But if it was left up purely to popular vote, then there was fear about what could happen, considering there was a lot of people that couldn't read, write, and were just generally uneducated. I mean, if you think Wi-Fi is bad now, imagine getting your news from somebody on a horse. So the Electoral College was their big compromise. The idea here was that electors were a lot more informed about the issues than most citizens, and therefore could protect our best interests if we accidentally voted for a crazy person. Of course, back when the framers were thinking about the best interests of the country, they weren't thinking about people like me. They were really only concerned about the best interest of property-owning white men, literally the exact opposite of your host here. So that's who they allowed to vote. But when they had to decide how many electoral votes each state got, they had a little problem. Slavery. Well, okay, that's literally not a little problem at all. It's actually a really big problem that was really messed up. But you see, if they counted slaves in their population counts when divvying up electoral votes, then the South would get way too much representation. So that's how the old 3/5 compromise came about, where slaves were counted as 3/5 of a person. Let me say that again. Slaves, they were people actually, were counted as 3/5 of a whole human being. But okay, back to the present day, where women, people of color, and poor people can all vote. Well, I mean, we still have voter suppression, which is happening all over the place, but that's another story for another day. Good old democracy. Gotta love it, right? There are a lot of people that argue that it's time to abolish the old electoral college. It's outdated and doesn't accurately represent the voice of the people. I mean, there's been 5 times in history where the dude who became president lost the popular vote. 2 in the last 20 years. Plus, aren't we all a little more informed now? Do we really need electors anymore? It's the reason why people say votes in more populated states count less. Like, check the math here. California gets 55 electoral votes for 37.3 million people. That's about 1 elector per 680,000 people. And then our friends in Wyoming get 3 votes for 568,000 people, or 1 vote per about 189,000. So you can see why people say a vote in Wyoming counts more than a vote in California. And keep in mind, 1 in 8 people that live in the US live in California. So that's probably why it takes me 2 hours to go 20 minutes to get home. People also argue that the Electoral College gives way too much power to people who live in swing states. Now, these are states where either candidate has a chance at winning the vote. See, in recent decades, some states are pretty much guaranteed to go with a certain political party. Like California and Massachusetts almost always vote Democrat, whereas Republicans can count on winning Texas and South Carolina. But states like Ohio, Florida, Pennsylvania, and North Carolina can swing either way. That's why we call them swing states. So candidates often focus on trying to appeal to these voters the most. And then there's the argument that the Electoral College makes it harder for third-party candidates to win. I mean, think about it. In order to win any electoral votes, with the exception of Maine and Nebraska, you have to win over the popular vote of a whole state. In 1992, Ross Perot ran for president as a third-party candidate. Now, that was probably a little bit before y'all's time, and quite frankly, mine too, but he was a pretty big deal. He ended up being one of the most successful third-party candidates, winning 19% of the popular vote, but he didn't get a single electoral vote. If we didn't have the Electoral College, it'd be a lot easier for third-party candidates to challenge the 2-party system. Okay, so you might be thinking, I'm sold. Let's get rid of this Electoral College thing. What's the problem? Well, for starters, if you just pay attention to popular votes, then the presidential candidates will pretty much just ignore rural America and the smaller states and the issues that matter to them. They'd only need to campaign in the big cities. Not to mention, abolishing the Electoral College would be insanely hard to do. It would require a constitutional amendment. That means a 2/3 majority in Congress and 3/4 state approval. When's the last time people in Washington agreed on anything that much? So to get around this fork in the road, some states have signed on to something called the National Popular Vote Interstate Compact. That is a very, very long name. This is basically a pact where states pass a law that says their electors have to vote according to the outcome of the national popular vote. But it only happens when enough states have signed it to make it to 270 votes. So far, 15 states and DC have passed it. So we're up to 196 electoral votes. And most people aren't holding their breath that we'll get to 270 anytime soon. Since most Republicans have benefited from this system over the last 20 years, states that lean red aren't too excited to join. And even if it does hit 270, the constitutionality of this thing will likely be challenged in court for years. A third option is that states split their electoral votes, kind of like how Nebraska and Maine do it. How it works in those states is that whoever wins the state's overall popular vote gets 2 electors, and then the popular winner of each congressional district gets 1 electoral vote. But according to an analysis by Fairvote, this method would mean it's more likely someone will win the presidency without winning the popular vote. So, for example, back in 2012, if we counted votes this way, Mitt Romney would have been our president, even though he had 5 million fewer votes than Barack Obama. So, America, we find ourselves in quite the pickle. This conundrum brings up some big philosophical questions about what it means for America to be a democracy. How do we balance whose voice is heard in a huge, diverse country like ours? Is it a problem that sometimes we elect presidents who lose the popular vote? Do you think the Electoral College is working how it's intended? Or is it time for a change? Let us know in the comments below. Oh, hey, look, you made it. You decided to stick.
Okay, I hope you enjoyed that video. I thought he did a much better job of describing the pros and cons of Electoral College than I ever could have. So I'm not going to restate all of that. I'll just leave it to you to digest what he had to say. Now we'll move forward to our last little topic, and that's we've gone through the qualifications for the president, how the president gets elected, talked about the powers that the president exercises while in office. Of course, the last thing we have to talk about is how the president leaves office. So we mentioned earlier the line of succession. If the president were to pass away or be unable to continue in the president's term, the next person in line is the vice president. And then the next person, I believe, is Speaker of the House. There's a line of succession that is established by the 25th Amendment. There is also a provision in the 25th Amendment where the president can be removed from office when he's unable to discharge the powers and duties of the office. This is known as a presidential disability. It's mostly just a temporary removal. For example, the president has to have a surgical procedure that requires the president to undergo anesthesia just for that time period of the surgery. The president is temporarily removed for disability, and the vice president steps in and takes on the role of the president for this temporary time period. Then when that time period ends, the president returns. That's kind of how this has worked over the past. There you go. Another way the president can be removed is through impeachment. This is an authority that is given, or power that is given to Congress to impeach the president. And it is not something that is taken lightly. Impeachment can only happen if the president has committed what would be called a high crime or misdemeanor. That phrase is not defined in the Constitution, so it's really up to the public to decide whether what the president has done is bad enough that the president ought to be impeached. So it's kind of a loose definition there. A simple majority of the House of Representatives will issue articles of impeachment. It's sort of like an indictment. It's just a document saying what the president has done wrong and that he ought to be put on trial for impeachment. The actual trial then is held by the Senate, the other chamber. So the Senate will hold an impeachment trial. The Senate will be in charge of dictating the processes, like will we take evidence? Will we accept oral testimony? What's the scope of our investigation going to be? Those sort of rules are determined by the Senate. They'll hold in a trial, and then you need a 2/3 majority. So this is a super majority from the Senate is required to actually remove a president from office. So it is particularly hard to accomplish. Several presidents have been impeached, and then most of them have either the trial has not succeeded in removal, and the president has just been censured for whatever it was the president was accused of doing. So it isn't something that is taken lightly at all, but it is there. It is an opportunity. It is a check and balance to maintain the separation of powers, to prevent the abuse of power by the executive branch, the fact that the president can be impeached by the legislative branch. That is the end of the lecture for Learning Module 6. Please proceed now to the other module requirements and email me if you have any questions.